Terry Brooks. Welcome to this video presentation on the iLight case. Now, the iLight case involved a disavowal of claim scope through a summation or conclusion and also a global statement. Twice a year for 4.5 years, I was an instructor in a nationally renowned course on crafting and drafting winning patents. And the leader or organizer of that course would tell students to not use the phrase present invention. Well, that certainly is helpful because lots of problems can arise from using that particular phrase. But as you'll see in this case, there's plenty other phrases that amount to global statements that can give rise to a disavowal of claim scope. And in this case, there's a summation or conclusion at the end of a response to an office action that gives rise to a disavowal of claim scope. But summations or conclusions can occur in lots of different places. For example, in a patent application, there can be a conclusion or summation at the end of a background section, at the end of a summary of the invention section, at the end of a description of the drawing section, at the end of the detailed description, and of course, the abstract can often be a summary or conclusion which can give rise to a disavowal of claim scope. So let's take a look at the iLight case. The iLight case is a non-presidential case, but it's still instructive and worth looking at. In that case, the patentee made several mistakes, including trying to sell the invention by referring in general to the invention and describing how an intended function of the invention was achieved by structural elements. In response to rejections under 35 U.S.C. 102 and 103, the prosecuting attorney argued, to achieve the desired light intensity and uniformity, the rod must preferentially direct light along its length while also urging light out the lateral surface. This requires an essentially solid rod with optical, waveguide, and light scattering characteristics. The prosecuting attorney also ended his argument with the summation or conclusion. Therefore, for the reasons stated above, applicants respectfully submit that none of the claims of the present application, now this is a global statement, as amended are anticipated or obvious. In doing so, the prosecuting attorney tied his remarks to all of the claims, including claims that did not recite a rod. The Federal Circuit held that the patentee disclaimed hollow structures as light waveguides used by the defendant by referring in general to a rod as being needed to achieve a desired function. Even though one of the claims did not include the term rod, the disclaimer was held to be directed to the invention as a whole. So a disavowal of claim scope was created by the use of conclusions or a summation and a global statement. So it's really, really important for patent attorneys involved in patent preparation and prosecution to look at every sentence they write and make sure that they mean what they say and say what they mean, because otherwise disastrous unintended consequences can occur. Thank you for watching this video presentation. I hope you found it helpful.